What's up, everybody? Welcome in to another episode here. We are breaking down the latest in Richard Allen's case. Some incredibly shocking and disturbing things are revealed in this motion, but some of the big questions are, is this actually new evidence and will it affect the outcome of the case? And those are the questions we're going to answer in today's video, along with all of your questions. So make sure you guys get them into the chat, hit the like button, and let's get to it. So a bunch of you guys sent me this, tagged me in it. I think I either pulled it from Sleuthy Goosey or Defense Diaries. I saw it was on their Twitter too. I can't remember where I actually clicked the button from, but thank you everybody for sending it to me. And all of you guys that had questions, because if people care about something and they have questions and they want to know, that's what makes this enjoyable for me. That's what I like to do. I like to break these documents down, read them, see what they mean, see what they say, answer your questions on them. I'm not going to be one that sits here and says, oh, this is an absolute fact, it must be true. Oh, this is absolutely not true, this person is lying. In so many cases, and that's literally why we have trials, is to have juries determine things like that, and literally why we have jury instructions that say you weigh the credibility of witnesses and evidence, because you can throw some evidence out. You can throw some statements out. Just because somebody got up there and say it doesn't make it true, it also doesn't make it false, and that's the point of having juries. But when you have situations like this where there's so much going on in the case, so much negative repercussions for somebody that's been accused of a crime and now convicted of a crime, but so much of what happened before was disturbing and problematic. We've talked about a lot of that, but this motion here is titled Defendant Richard Allen's Verified Motion to Correct Errors. Okay. I don't know if this is specifically an Indiana thing or what the different rules and procedures are in different cases. But the way I'm looking at it is what they ask for, right? What the relief is that they ask for is that the judge vacate the conviction. And if they vacate the conviction, a new trial would come shortly after, or they want a hearing to discuss this, see what the remedies are, see what they can do about it, okay? The first section focuses mostly on a procedural issue when Richard Allen was put into protective custody, basically, whether or not he wanted to be there, whether or not he had the opportunity to object, whether or not he had the opportunity to have a lawyer there. He had a lawyer. They weren't notified. Were his rights violated at a significant step in the procedure? And from my perspective, we'll get to that if we have time. I'll just say, I got about an hour. So if we have time and we finish the rest of the motion within that hour, we'll go back and check out the first 7 or 8 pages of this document. But generally speaking, unless the judge finds that this violated his right to counsel for the entire trial and throws out the trial, which I would be absolutely shocked if they did that, it's probably something that the remedy is not going to be throwing out the trial. They can't redo that hearing. If they would, what prejudice did it cause? You know, obviously I know a lot happened in jail, but can they prove that it wouldn't have happened if they didn't do this, or that if he had a lawyer there, they would have been able to stop it? Would he objected to it? It is a procedural issue that will be discussed more in detail by very smart appellate lawyers, and eventually an appellate court will make the decision on it. Like I said, if we have the opportunity to go back and see if it is an issue that really affected the entire process and procedure, that it was unfair from day one, and therefore we have to throw it out, that the results don't really matter, then sure, it could be a smoking gun, big ace up his defense attorney's sleeve. But I think what most of the discussion has been around, and most of your questions have been around the other sections of this, the facts that were brought to light today, that were made public, that we're going to be here to discuss. And we've discussed in a lot of the civil cases, a lot of the celebrity cases, where are lawyers using the public to get certain information out there? Are the lawyers using the public to affect the case and affect how people see the case? Okay. And I do think, as I read this motion, and you'll kind of hear my thoughts on it, there might be, and I'm not saying that this is something nefarious or horrible or things like that. That's the point of the public eye, right? If there's injustice going on, you want people to know about it. You want people to cry out and fight for justice, right? But I do think that there is an aspect of this that wants the public to know what's going on. And this, and I'm using air quotes not to be disrespectful, but shocking new evidence, as it's been titled and discussed throughout Twitter and the internet, I do think has the effect of people getting up in arms about an injustice. And you know, I'm a big fan of justice here. I like fighting for justice, dedicated my life to it. But let's talk through whether or not this is really new evidence and whether or not this really is going to have an effect. I mean, I'll let the cat out of the bag, and spoiler alert here, I don't think Judge Gohl is going to vacate the verdict in this case. I think that this is going to be something that's going to be taken up on appeal. She might not even give him a hearing. I wouldn't be surprised if she didn't give him a hearing, although I do think a hearing is always a good thing. If I was a judge, I'd probably have more hearings than I need, because I like to let lawyers do their job. I like to hear the arguments back and forth before I make my decision, but that's kind of the point of these written motions. So let's get to it here. And of course, it's important to protect the record, although appellate courts, usually what happens in the trial is the record, and this additional stuff is not necessarily part of the record, but maybe they can try to argue it and put it in it. Those are all appellate issues that I could go back and forth on for days about, well, this, then that, if this, then that, this argument, that argument. Let's focus on what the defense talked about in this and get your questions answered. In violation of the Due Process Clause, the 14th Amendment, and it's, this case and its progeny, the state presented the testimony of Brad Weber that Mr. Weber arrived home in his white van about 2:30 p.m. on February 13, 2017, either knowing that testimony was false before it was elicited or failing to correct it once it had been elicited. So just to give you a little bit of background, actually, I'm sure they do this in the motion, but for those of you that don't necessarily know or want to catch up, one of the big deals was Richard Allen has all these confessions. In a bunch of these confessions, there was, horrible jail conditions going on, mental breakdown, maybe hitting his head against the wall. But did he reveal anything that only the killer would know? And the big fact that a lot of people talked about was the white van that scared him from hurting the girls, and instead he just decided to end their lives. Because that's important. It's a really important fact, because a lot of what Richard Allen said was just factually not true and provably false. And the defense used that to argue these confessions were in fact false. But the white van, is that actually a fact we can prove? And the state proved it with Brad Weber, who would have been there at the time, driving his white van. Therefore, Richard Allen had to be the guy, had to be bridge guy, had to be committing the crime because he was there at the time, saw the van when Weber drove by and did the criminal act on these girls. So it was a big point in this case. And even the juror that was interviewed, even though that's not going to come in as part of the appeal, the juror that was interviewed discussed why that was a big deal as well. Okay. A conviction obtained through use of false evidence known to be such by representatives of the state must fall under the 14th Amendment. The same result obtains when the state, although not solicited false evidence, allows it to go uncorrected when it appears. So they start this discussion that the state presented evidence they either knew or should have known it was false or found out later it was false. And to take that point, it's a very important concept and something that should be an absolute hammer drop if the state ever does it. The state attorney's office, as we've known and we've discussed so many times on this channel, has so much power. So much power. Law enforcement, state attorney's office, when you arrest somebody and prosecute somebody, you can ruin their life, even if you drop charges later. When you put somebody in the defendant's chair and they sit there, most jurors or prospective jurors come in and just assume that person's guilty. Why would the cops arrest him? Why would the prosecutors prosecute him? They have so much power and they know it. They have all the leverage. That's why there's some false confessions made in plea agreements where they're like, yeah, I'll say whatever if I can get 1 year instead of life in prison. And then now you're a criminal forever. You've even agreed to it. It can be used against you forever. They have so much power. So if they start presenting false testimony or don't do their due diligence when they should and they know something is false and they present it, that should be prosecutorial misconduct. That should be sanctions against these attorneys. They should lose their bar licenses. And obviously, the judgment should be vacated. But what does that look like? What does it look like to knowingly present something that's false? Because a lot of people say, lawyers all the time say, that lawyer knows this witness is lying, or they know his client is lying. Or if an expert changes or adds something to their testimony, they must have been lying. Well, that's not always as easy as it sounds. People do change their testimony sometimes. People do change their mind. People do learn something new and change the way they look at something. People do misspeak. People do stretch when they don't actually know something. And then when they come to find out, they're like, yeah, I didn't actually know before, but I know now. So where does it really become knowing that somebody is lying or that it's false testimony? We have to keep that in mind as we discuss this. At trial, the undisputed evidence was that LG's cellular telephone stopped moving at 2:18 p.m. I'm going to stop a lot, okay? Because a lot of this creates discussion. I'm going to draw on a lot of things that we have experienced together. If you followed this channel for a while, some of the other trials that you have watched with me. I'll bring some of my real life cases into the analysis as well. So, if you remember that in Murdoch's case, for example, when the cell phone would stop or when it would go off, time of death. That's how we can prove time of death. Other cases, things happen from the last use of the cell phone to when the death occurred. So it wasn't the specific time of death, but it was kind of a range. Well, LG's phone stopped moving at 2:18 for 7 minutes until 2:25. It then started moving again and stopped moving permanently at 2:32 p.m. And we have seen lawyers argue that's got to be the time of death, or that's when the phone hit the ground or whatever, something happened and they could have continued staying alive for a period of time and then passed shortly after. But in this scenario, the prosecutors made a choice. In closing argument, Mr. McClelland called it a hard fact that her phone stopped moving at 2:32 p.m. And the state introduced an alleged confession by Mr. Allen to Dr. Walla, a psychologist contracted by the Indiana Department of Corrections to treat inmates at Westfield Correctional Facility. In the confession, Allen stated he abducted the girls, forced them down the hill, and he was planning to assault them, but he was interrupted by a van. And he was scared when he saw the van, and that's why he didn't assault them. And the van crossed Deer Creek from south to north from the property. Sorry, he saw the van and crossed Deer Creek from south to north from the Weber property to Ron Logan's property. Those names are both important. Taking LG and AW with him. The state also introduced the testimony of Brad Weber that he left work at the Subaru factory in Lafayette, Indiana at 2:02 p.m. and arrived at his home in his white cargo van about 2:30. From Mr. Weber's testimony, the state argued Mr. Weber's arrival home in his van was what interrupted Mr. Allen, causing him to take LG and AW across Deer Creek to kill them on Ron Logan's property. The arrival of Mr. Weber's van about 2:30 was a detail only the killer would know, said the state. Okay? My perspective on this. I think that's a pretty good argument. I think that's setting up a good timeline if you're the state. Richard Allen gave you that nugget if you believe that he confessed to Dr. Walla. I've heard people say there's ways to figure out how Richard Allen could have gotten to know that there was a white van, but generally speaking, new fact. All lines up, and the state says Weber came back at 2:30, and phone stopped moving at 2:32. That's the timeline they set up. The problem is, the state also contended that LG and AW died near in time to 2:32. When Apple Health data from LG's phone showed that the phone stopped moving, the arrival of Mr. Weber in his van interrupted Mr. Allen, forcing him across Deer Creek. Mr. Weber would have had to arrive near his parents' house at the end of the private drive before 2:32. We can agree. When, according to the state, the phone stopped moving and was located on the north side of Deer Creek. So this is why I hate the fact that we're not sitting there in trial. We didn't hear the closing argument ourselves. But did the state say 2:32 is the time of death or sometime thereafter? Because sometime thereafter, people are not going to like this. Sometime thereafter at least leaves open some period of time that the state would be able to say in good faith they believe. And if they have a good faith basis to believe it, I might not like it, you might not like it, witnesses might not like it, judges might not like it. If the state has a good faith basis to believe testimony that's either shaky or changed or different, it's usually enough to get past prosecutorial misconduct. I hate to say it, shouldn't be how it is. If you're fighting for justice and you're an administrator of justice and something like this came out, I'll just tell you, if I was a prosecutor and this information that we're going to read, if this was in my possession, this might be enough to just drop the case altogether. But again, you want to find justice for these victims and their families, for the whole community. You want to have a face to put out there. You want to have somebody to convict. So it really butts heads when you're really talking about what does administering justice mean. In fact, Mr. Weber could not have arrived anywhere on the private drive before 2:44:54 p.m. on February 13, 2017. His arrival at about 2:30 could not have been a detail only the killer would know because it did not happen. So a couple things, okay? A lot going through my mind here. Does around 2:30 include 2:44? Did the way the state presented the argument leave open the possibility of the deaths occurring at 2:46, 2 minutes after 2:44? That's a question. Now, I believe I remember hearing the defense argued Brad Weber was not even home. He was out checking ATMs, which is like his job. I guess he either owns or leases or whatever, some ATMs. And he was out there. He wasn't even home. So this is even a bit of a different argument for the defense, which is okay. It's okay. You get more information. Your opinions can change. Your arguments can change. But I think the defense argued before this was impossible because Weber wasn't home. But now they're saying maybe he was home, but not until 2:44. And if I tell my wife I'm going to be home about 2:30 and I get home 2:44, is she going to be mad? Depends on the day. By the way, I am freezing. I have a blanket on right now because my wife, whom I love so much, does not believe in heat. She thinks it like gets the kids sick. So instead, it's just freezing here in our house. And I know a lot of you guys are in like -6-degree weather, but 40 degrees in Florida is, I'm freezing. Okay. The state knew or should have known as much. The state either elicited Weber's testimony about the time he arrived, knowing it was false ahead of time, or failed to correct the testimony once it had been elicited. And again, the state believing about 2:30 could also be 2:44. Defendants Exhibit 3A, as attested to by Matthew Hoffman and Defendants Exhibit 3, is a video recording made on February 13, 2017 by a security camera that was housed at 5998 West Country Road, 252 North. The video recording was provided. Okay, so here we go. A couple of these sentences are going to be some of the most important ones to me. The video recording was provided to the defense by the state and has therefore been in the state's possession. So while they say this, okay, that this video was in the state's possession, they are using that argument to say state knew it was false, presented anyways, prosecutorial misconduct, eliciting false testimony throughout this trial. That's what they're using it to say. But the other side to that coin is that the defense also had this video. And I know there's going to be people upset with me about this. I got to go check out what, Lawyer Lee and Andrea and Defense Diaries and, the people there that were fighting hard and firmly in the camp that they believe this should have been a not guilty verdict. And there was all sorts of issues with the prosecutors, the judge, obviously the jail conditions. I had all of them on. I, respect their opinion. So I do want to go check it out. But this sentence here, the fact that the defense had, I believe, all of the evidence and shocking discoveries we're going to read throughout this motion before the trial. The fact that they had it before the trial is, in my mind, going to be the most difficult hurdle to overcome for them in making any of these arguments successful. Because my first thought, if I was an appellate judge, would be to say, hey, Mr. Rosie, Mr. Baldwin, amazing argument. Really good argument. You could blow their timeline out of the water. So why didn't you do it? Why didn't you just present the video evidence? Why didn't you cross-examine Weber and say, you didn't get there at 2:30, you got there at 2:44, sir? And one of the reasons it's so important to do this during trial and not save something, I'm literally 2 pages into 15 pages, by the way. I'm going to have to pick up the pace here. But The reason that we don't want to have a second bite at the apple or hold back some evidence, it's like, I had this argument, but I saved it in case we lost to appeal it, because for a couple of reasons, we don't want to do that. Number one. Number two, it's so hard to win an appeal. So you wouldn't do that if you were a defense attorney. A much better chance to win at trial than you have to win an appeal. But the third issue and reason is, if you would have asked, was there a logical explanation? Could the witness have explained? Could the state have explained? Was 244 the same as 230-ish? Et cetera, et cetera. Now, I think that the state's argument was a tighter timeline. 232 was the time of death, 230. So I don't think they really left a lot open for being vague. But I do think that's an issue that we're going to continue throughout. The security camera faced northwest, and appears to have recorded continuously. Based on the date and time stamps on the video, it appears that the security camera was set to record date and time information as part of the recording. The time on the security camera was set 12 hours behind, such that 12 a.m. is really 12 p.m. on the same day. This is apparent due to the daylight and moonlight on the video and the associated timestamps. So again, there's a lot I don't know, but how do they know? Are they just saying because it says 2:40 and it's daylight, so obviously 2:40 a.m. would be dark? Because if you know it's at least 12 hours off, how do we know it's not 14 hours off? How do we know this is even the right day? Because 12 hours, it could be a different day, right? So, I mean, I don't know the answer to that. Maybe the state told them, maybe they agree on that, but just throwing stuff like that in there leads me to believe there's some unanswered facts here, some unanswered questions that we would have to go through to really dig in. The security camera had a wide angle lens. Did I read this? Private property, timestamps, shows a white car going by. So let's just play the video real quick. Okay. I don't purport to know that this is 100% one thing or not one thing, but we'll watch it real quick. Let me make myself smaller. It's going to be like right here. That's where we're going to see it. I'll move my cursor. So here it comes. Here's the white van that they say. Okay. And they zoom in and they have a picture of Weber's van. Here it is driving through. Okay. 244 on 213. Okay. So does that absolutely prove that that is the white van? Not necessarily, but there's more information to come. That's still going to be helpful to the defense, even if that's not Weber's van. Okay, good. You guys are really smart and asking good questions. I don't know if now's a good time. Let me read this section and then I'll answer some of the questions. Exhibit 3B is a video file that contains 3 zoomed clips from the video recording that is Exhibit 3A. Each successive clip in Exhibit 3B is zoomed in greater, okay? Number 1, just before it passes, the White House. Here's the white van. You can see it's kind of blurry. It's not the easiest thing in the world to see. Other video files produced by the security camera in the state's possession. Okay, so here's another great point for the defense. Well, it's his house, right? He could have gone back and forth multiple times that day. Well, the defense checked the video. Other video files produced by the state, meaning the state has it, provided to the defense in discovery and covering the time from 2 p.m. to 4 p.m. on February 13th, do not show any other van driving north on that road into the private drive of the Weber property. If Mr. Weber returned home in his cargo white van, he could only have arrived some minutes after 2:44, because it was even after, right, that he would get all the way up to the house. 12 minutes after the time, the extraction of LG cellular telephone shows the telephone stopped moving at 2:32 p.m. I think that's a great argument. That nukes the state's timeline if they're going with 2:32 p.m. Either the white cargo van shown in Exhibit 3A, 3B, and 3C is Mr. Weber with him arriving some minutes after 2:44, or it's not. In either event, no white cargo van or any other van entered the private drive to the Weber property after 2 p.m. or before 2:32 p.m. on February 13th, 2017. Time of the extraction of the cell phone. Defendant's Exhibit 3E is a redacted FBI subject information sheet on Bradley Weber. Is dated March 3rd, 2017. The unredacted version, Exhibit 3B, is in the possession of the state. Mr. Weber says on 2/13/17, Weber's phone pings to his parents' address overlooking the crime scene initially at 2:50 and repeatedly pings around the property until 11:55 p.m. Mr. Weber's phone first pings at his parents' house address at 2:50. That's consistent with the video. I agree. That's great. Weber could not have arrived at the home in his white cargo van until sometime after 2:44 p.m. that day. All right. So before we get, actually, let's read this. Also, I still drink iced coffee even when it's cold. I love iced coffee. From both Exhibit 3A, the security camera video recording, Exhibit 3E, the FBI subject information sheet from Mr. Weber, the state either knew that Mr. Weber's testimony about the time of his arrival home would be false before it was elicited or failed to correct it. When the state introduces testimony it knows will be false or fails to correct testimony it knows or should know to be false, once elicited, a conviction must be vacated or reversed if that false evidence may have had an effect on the outcome of the trial. I mean, no doubt in my mind this had an effect on the outcome of the trial, right? Can't use the jurors' words, but I mean, this was the big fact that corroborated Richard Allen's wild confessions that had a lot of issues, but it's a big deal. To receive a new trial, the defendant must show that there was false testimony, that the government knew or should have known it was false, and that there's a likelihood that the false testimony affected the judgment of the jury. Okay, so is this almost done? Okay, let's just finish this section because I really want to answer your questions about this section. To obtain Mr. Allen's convictions, the state explicitly relied on Weber's testimony about the time he arrived home and used that testimony to corroborate Dr. Wall's rendition of Mr. Allen's statement that he became scared after he saw a van, so he took the girls to the north side of Deer Creek and killed them. This was the only statement allegedly made by Allen that contained a detail of the murders that might be true. State therefore cannot show Mr. Weber's uncorrected false testimony about the time he arrived home did not have an effect on the outcome of the jury. Alternatively, were the court to find that the state did not know or should not necessarily have known the security camera video subject information sheet for the FBI, Mr. Weber, then both exhibits constitute newly discovered evidence that would probably produce a different result at a new trial. Accordingly, for either reason, the court should either vacate Mr. Allen's convictions or set this motion for hearing. I've never seen this argument win. That because one side or the other didn't use it or maybe didn't even know something was in the discovery that it becomes newly discovered evidence. I don't think that's a very good argument, number one. But let's get into now, was the state lying? Did they know or should have known? A lot of this comes down to the way the state argued, which I don't have a transcript and I was not there to listen and we were not able to listen to the stream together. But if they dug their heels in and made a decision, like I said earlier, to say 2:32 is the time of death or 2:33 or something like that, this timeline is pretty blown up. But if they have arguments that there's other ways to get to the residence, or there was another car that maybe you didn't see on the video, or the timestamps on the video, or you didn't look at the right hours on the video, we have to realize, like we say with every motion, this is a motion written by good defense attorneys. It's going to seem like they're right and they're winning the argument. But if it's true that, we got experts to say this video was at 2:44 p.m. He couldn't have gotten home until 2:46, which lines up with the 2:50. His phone starts pinging. He could not have been there at 2:30. The state presented that evidence. It's false. They didn't correct it. They hung their hat on it in closing argument. I think it's a pretty good argument. I don't think Judge Gold is going to buy it. But it's a pretty good argument on appeal that the state elicited false testimony. Now, does that mean Richard Allen's innocent? Right? Another question a lot of people have. Well, what it could do is just change the state's timeline if they were to have to try this case again. Again, I don't pretend to know every detail about the case, but if the time of death was 2:46 instead of 2:32, what would change? It would have to be more than just the phone stopping moving, because the phone could have fallen, could have been thrown, could have been hidden, could have stopped moving. They could have been on the ground. A lot of things could have happened. All right. Thank you, DB, for the super chat here. Any chance you'll cover the Maya briefs, at least partially? Example, chapter 39, wrongful death sections ahead of the oral arguments. So I thought you were talking about the lawyer stuff. So I don't know if I'm going to cover the Maya appellate issues, but I'm definitely going to cover the Maya lawyer infighting. That's wild, and I think could have a negative effect on the case. The state did not leave that open as a possibility because they said Abby fell to the ground with the phone under her, which makes the time the phone stopped moving 2:32 p.m. the time of death. So thank you for saying this, Idiot Wind. I just realized that was your name. Because here is the issue, okay? And this is, let's take that off the screen for a second. So this is the issue with having holes in the story as the state. Jurors, people that really want it to be guilty, they start filling holes. They start saying this is probably what happened. And if you're the prosecutor and you start doing it, you can really get yourself in trouble. Because if you don't know that this is when she fell and she fell on top of the phone, if you don't know whether or not she was moved or not, and you take too many reasonable inferences and you connect too many steps in that chain that you can't prove, you could end up arguing a point or stating something, a fact that later is disproven. As opposed to, we don't know how the phone got under her back. We don't know if it fell. We don't know if she was put there afterwards. Because that leaves open, our timeline's not perfect. This is what we have. And guess what? We have a van driving by. Richard Allen said he saw a van and was startled by a van. Timeline fits-ish, right? 2:32, 2:44. But if you start filling holes with facts you don't have evidence for, that's what creates real issues. And I've talked to some people in this case that firmly believe Richard Allen is guilty, and the state proved it great. And I will just tell you, this motion is poking holes where they tried to fill them with, this is probably what happened. Sleuthy said, wouldn't that simply be an argument for ineffective assistance of counsel made by appellate attorneys? As a side note, we don't know what all wasn't allowed by the judge. 100%. And we're about to get into the second big, bombshell section. And a lot of this was kept out by the judge. And we'll talk about that. But to me, if the defense did not try to use this stuff to blow a hole in the timeline, it's absolutely ineffective assistance of counsel. And I'll continue this discussion with Michelle's point, which a lot of people made. Peter, Weber's testimony was an ambush at trial. They couldn't have argued that. Okay, so we don't like trial by ambush. We don't like hiding the ball. But different accounts of the story are available to impeach witnesses. Most of the time, unless they're incredibly egregious, the judge will still allow a witness to testify. Something different being stated at trial. And here's another thing I don't know. I don't know if Weber never said anything about a white van, if they never had any clue. If Richard Allen said the white van in the confession, some could argue the defense could have gone back and looked at that video that was produced to them to see if a white van drove by. Maybe they never did. Maybe they did and didn't see it. I don't know. But what I'll tell you is, I don't just blow smoke about trial law being difficult. Trial lawyers have a very difficult, a very stressful job. We are trying to remember a million things. We're reading depositions, following along with testimony at the same time, standing up and objecting the proper objection, arguing with a judge sometimes, arguing with other lawyers, keeping our client in the loop of what's going on all at the same time. We have to be ready to respond. We have to be ready to cross-examine witnesses. Then to come up for another redirect, to respond to whatever was asked on cross. We give a closing argument, then we respond with a closing argument, and then sometimes with a rebuttal argument. Lots of trial law is bobbing and weaving. Everybody's got a plan until you get punched in the mouth, as Mike Tyson said, the great philosopher. And so what I will say is, ambush better mean ambush, in that there was no way that they could have ever known this white van was there, or they could use this evidence to put a hole in the state's timeline. Because if they knew about this video, they had this video, they logged it, and I'm not blaming them. I'm not calling them idiots. It's difficult. I'm sure I've missed things in trials before. I know that after closing arguments, I was like, dang it, I didn't say this. I wish I would have said that. I said it better when I practiced it before, right? That happens to every lawyer. But if you have this piece of evidence, you hear that evidence come out at trial, you know this evidence exists, you put it up and you respond. And the fact that they didn't do that, and by the way, criminal defense attorneys are not shy. They don't care. They want their client, especially if they believe their client's innocent, they want their client to file an ineffective assistance of counsel claim. Most good defense attorneys don't take offense to that. And I'd be willing to bet these attorneys would tell Rick Allen's appellate attorneys, file it. We didn't make this argument. Ineffective assistance of counsel. If that's what's going to help him get a new trial, go for it. Because that is part of trial work, and we're going to cover that more when we get to the next section. Thank you, Azam, for gifting 5 memberships. All right. This is something new. We did this. Okay, here we go. Ron Logan, the next bombshell. Ron Logan's confession to Ricky Davis before May 15th, 2017, is newly discovered evidence entitling Mr. Allen to a new trial. Dr. Kaur, hold on one second. All right. Dr. Kaur was the forensic pathologist who conducted the autopsies of LG and AW. His original opinion held for years about how LG and AW died was that 2 weapons were used, one serrated blade and the other a straight-edged blade. For the first time at trial, having a eureka moment at his tool bench, Dr. Kaur opined that the girls could have been killed by a single box cutter rather than 2 different knives. Okay. I remember hearing about this coming out. I remember people being upset about it, saying, holy cow, this is something completely different. This could open up all sorts of other arguments. They're going to try to say Richard Allen had access to a box cutter because he worked at CVS. Like, big deal. Who doesn't have access to a box cutter? Right? But let's hear the argument they're going to make today. Defendant's Exhibit 4A, as attested to by Matthew Hoffman in Defendant's Exhibit 4, is a redacted copy of a tip from the Orion database of tips dated May 15th, 2017. In that tip, which the state has always had, Ron Logan is alleged to have confessed to Ricky Davis sometime before May 15, 2017, while they were in prison together, that he killed LG and AW. The material part of Ron Logan's confession to Ricky Davis, as it appears in Exhibit 4A, is reproduced below. Ron Logan's confession to Ricky Davis, as reflected in the tip in the Orion database and made a mere 3 months after the girls were killed, was detailed. Law enforcement followed up on the tip. Defendant's Exhibit 4B, as attested to by Matthew Hoffman in Exhibit 4, accurately reproduces the handwritten notes taken by Indiana State Police First Sergeant P. Hansard about his interview with Ricky Davis on June 21st, 2017, at the Newcastle Correctional Facility regarding Ron Logan's confession to Ricky Davis. Those handwritten notes of First Sergeant Hansard are attached to Indiana State Police Detective N. Wolf's lead narrative summary cover sheet as it was provided to the defense in discovery. First Sergeant Hansard's notes of this interview with Ricky Davis about Ron Logan's confession provide more detail. So this is the handwriting. I'm not even going to try to read it. They put down here what they think they said. Okay. And obviously they're making the arguments. So this is going to be in a light most favorable to the defense. It seems to say, talking about knowing one of their dads, to walk with them. One of them wanted to turn around. Grab the youngest shoulder. It's okay. Oldest freaked out. One said something about calling police. The S attack was not true. Originally not trying to go R them. Paranoid about probation. Felt like he crossed the line when he grabbed the younger one. He started talking. Ironic. They should have been in school. Knew one of their moms waitressed at a bar. Animals walked with them. Willing to go check out horses. XX meaning couldn't read it. He told them he had rabbits in his barn. Walked through trail and woods. Oldest paranoid didn't want to go. Youngest wanted to see the horses. Oldest turned to help the youngest. Oldest started looking, kicking. Youngest seemed something. He now grabs oldest. He said he got hit in the nose, scared. He got blood on one of the girls. Pulled the box cutter out, cut the oldest, hit an artery. Youngest was scared. Took the little girl with him for a while, never said where, and he cut her to cut both necks. He left and came back again later in the evening, search going on. Later on, late hours, tried to move oldest one to area not going to be found, place where four-wheelers go, burned his clothes in a burn pile, hiking, walking boots, gloves, bag. Sole of boots might be in the burn pile. Next morning, 2 other girls knocked on door asking to search on property. Feel weird if he said no. He let them take off, got a hold of a family member, and got out of the area. First time he's seen them on property, home, etc., guns, etc. During the struggle, the young girl not happened to friend to stand there, head, neck, artery. Okay? My first thought when reading this is, how in the world would a jury not be allowed to hear this? How in the world would we not be allowed to have a third-party culprit defense in this case? If I'm the defense and the judge doesn't let me get stuff like this in, there's got to be a reason. I don't know the reason. A lot of this stuff is not public record. Did they make the argument? Did they try to say this needs to come in? I know he was on the list of third-party culprits. I know specifically that the judge limited him out. Why, though? Was this Mr. Ricky Davis? Was he unreliable? Was he known for lying? Did he do this in the past? Make up stuff that was completely not true? Did he die before they could take his deposition? I don't know. I know Ron Logan is no longer with us. But why was this not allowed to come before a jury? That, to me, I mean, we know, right? And again, I talked to some people who thought this was for sure guilty verdict. We heard from one of the jurors, and we've heard multiple times, if not Rick, then who? And that's a plausible question. In some cases I've handled myself, we've had that question. And when I was early in my career, like first couple trials, my dad was like, this is a good third-party culprit. You got to have a third-party culprit, even if you got this much to say it might be somebody else. And I was always like, I don't know. There's so much more evidence against our client than that client, or than that person. And it's like not just a prove it case, and it's a case-by-case basis. But my dad would tell me how important a third-party culprit is for anybody on the jury that finds any doubt with our client. If after they find some doubt, they sit there and they think, yeah, but who else could it really have been? You better give them somebody to say, it might have been them. We don't know, but it might have been them. And the third-party culprit defense, I agree. You can't just say Peter Tragos did this. Peter Tragos, who's never been to Delphi, Indiana, no connection, no issue. So ever since that day, when we have a potential third-party culprit, we include it vigorously. Only when we have a good faith basis, of course. And the problem is, when you cut all that out, and the jurors are asking themselves, well, who else could it be? Nobody else was there. Nobody had an opportunity to do it. It's like, that's just not true. And then in this case, because every case is a case-by-case basis, it's like, well, Richard Allen confessed. So it's like, who else is going to do something like that? Well, it turns out you have this one and some other ones that could at least somewhat be taken as confessions of this crime or as some sort of wrongdoing around this. That was not allowed in. It boggles my mind. But it sounds like the defense had this, right? Sounds like the defense had this. And we're going to talk about something they could have done, even though third-party culprit was struck and they tried multiple times to get it in. So let's read some more of this. Defendant's Exhibit 4C is a handwritten note signed by Ricky Davis, dated June 21st, 2017, the same day First Sergeant Hansard interviewed him. That handwritten note is attached to the same lead narrative summary cover sheet and is contained in the same file as First Sergeant Hansard's handwritten notes that are Exhibit 4B. Ricky Davis' handwritten note about Ron Logan's confession to him says, Mr. Logan has made reference to the killing in Delphi, Indiana. He told me that he was the one who had killed those girls, that it got out of hand. He walked back with them to the woods to his property. The girls wanted to turn back, said something about walking the blank. He grabbed the youngest girl to reassure her it was okay. However, they panicked, and he also panicked. He indicated he ended up cutting the old one with a box cutter. He went on telling me that he killed both of them because it was took too far. He ended up getting popped for a violation of probation. So in addition to the other details that fit the known facts, Ron Logan confessed to Ricky Davis that he used box cutters to kill the girls. If instead, for the first time at Mr. Allen's trial, Dr. Kaur said 7 years earlier that the girls could have been killed by a box cutter, there would certainly be probable cause to arrest and charge Ron Logan with the girls' killings. As it was, the FBI, 2 months before Ron Logan's confession to Ricky Davis, had obtained a judicial finding of probable cause to search Ron Logan's property. Under the circumstances, Dr. Kaur's testimony about a box cutter possibly being used to kill the girls makes Ron Logan's confession to Ricky Davis newly discovered evidence that would either be admissible through Ricky Davis or through First Sergeant Hansard under the Due Process Clause of the 14th Amendment. Ron Logan's confession exculpates Mr. Allen and would probably produce a different result at trial. Accordingly, the court should either vacate Mr. Allen's conviction or set this motion for hearing. So I do agree. I think this would have been a big deal. But let's talk about for a second the box cutter nexus. Okay, and we'll kind of work backwards. First off, box cutter, new information connecting to Ron Logan. Did the defense try again and ask the judge again, a motion for reconsideration, judge, in his confession, he said he used a box cutter. We need to call Ricky Davis or the detective. We need to put on Ron Logan's testimony because now he has used yet another fact that only the killer would know, and it connects with the state's own evidence and witness and expert testimony. Did they do that? I don't think they did. I'm not positive, but from what I remember, I don't think they did do that at trial, which again, to Sleuthy's point in question and Michelle's question, I think that's an ineffective assistance of counsel claim. And for other people that want to say, like Michelle said, they were ambushed with the box cutter comment, they argued how many times? Multiple times about this third-party culprit evidence. The Facebook photos, the crime scene photos, Odinism, a lot of details. And again, I'm not trying to harp on them. I'm not trying to blame them. So people are saying, yes, they did. They had a subpoena for Richie, whatever his name is, and she denied it. Okay, so then maybe cross that ineffective assistance of counsel off. So when you have something like the box cutter, and that just goes to show these lawyers know the case, right? They know the case a billion times better than I do. Okay, so I don't want any of this to come off like I think I know the case better than them. I very clearly don't. But that's step number one. They have to try to do that. But when it comes to another ambush with this box cutter comment, there are a couple background questions that are important. Number one, when did this expert first say this to the state? Because if they told the state earlier on, the state knew about this, they knew they were going to elicit this, and they didn't tell the defense, I would have a problem with that. It's a discovery violation. It's an undisclosed opinion. It's a big problem. But if you remember, we're going to recall from another case a lot of us watched together, the Sarah Boone trial. The Sarah Boone expert also had a new opinion at trial that was not disclosed at a deposition just days earlier. And what did the judge do in that case? Well, he let Mr. Owens kind of do a deposition there in the middle of trial. And that one, the state argued, well, you didn't ask her if this was specifically her opinion. And the defense was like, I asked if you had any other opinions. And if you remember, my analysis and opinion is, if you ask if you have any other opinions, this is not hide the ball. Tell me your other opinions. Don't hide your opinions until I specifically ask for each one. You know why we're here. Tell me your opinions so we can talk about them. That's a fair question. I disagree with the state's arguments. I agree with the defense. So if this was a newly undisclosed opinion that the state knew about, that's a violation. If the state didn't know about it, if the first time the state heard about the box cutter, it was on the stand, what should have been done, in my opinion, is that should have been struck. That's an undisclosed opinion that an expert should not be able to testify to at trial. They should strike that opinion. The jury should not consider that it could have been one weapon and it could have been a box cutter, and therefore they would have only considered that it had to be two weapons, which is what the state or the defense was under the impression of, the state's expert's original opinion, and goes to the defense of there was two people. But if that objection was denied, I think that's an error by the judge, because I think it should have been struck if it's really a brand new expert opinion. But When something like that comes out, because I'll tell you right now, I've had cases, especially when you prosecute cases and you have law enforcement officers, right? Especially at the state level. It's like they come in, they forget something, they say something different. You're constantly having to deal with witnesses saying different things. So it does happen. DB said they objected, moved to strike a trial. It was denied. I mean, that's crazy to me. Not surprising, but wild to me that the judge would deny that. If it's a first-time opinion that you don't have the opportunity to respond to with your own expert, to go and search for evidence that may corroborate a box cutter or deny a box cutter, that's a problem. Shouldn't be how it is. So it's either a discovery violation or the judge should have struck it, in my opinion. Is that going to be enough to overturn the verdict? Probably not on its own. But with a litany of other errors, it could become a much, much bigger deal. Break in the dam. Where is interim attorney Labrador? I don't know what this means. Maybe you guys do. Okay. Let's keep reading. I'm sure you guys have more questions and we will discuss it more. Defendant's Exhibit 5, the affidavit of Stacey Eldridge states that dirt or water damage to the phone could not have caused the auxiliary jack on LG's phone to log wired headphones plugged in and wired headphones unplugged. Ms. Eldridge's expert opinion is newly discovered evidence that would probably produce different results at trial. At trial, Mr. Allen introduced evidence that the testimony of Mr. Eldridge, a digital and mobile forensic expert, that someone plugged wired headphones into the auxiliary jack on February 13th at 10:32 p.m. To counter this, the state offered the result of a seat-of-the-pants Google search by First Sergeant Cecil, the state's expert. According to First Sergeant Cecil, Google hearsay told him, in his expert opinion, the log on LG's cell phone showing wired headphones were plugged into the auxiliary jack and unplugged same day could have been caused by dirt or water damage. Defense had no opportunity to counter the expert opinion. So that would be Sir rebuttal, I assume. I can't remember back if they asked for it. It was probably denied by Gull. Court should read Ms. Eldridge's affidavit in its entirety, but the short version is nothing in the data of LG's phone indicated it had been water damage. None of the reports or extraditions related to LG's phone created by law enforcement officers reflect dirt or water damage to the phone. Photographs of LG's phone taken by the Indiana State Police do not show the phone to be wet, dirty, or covered by debris. Eldridge is unaware of any scientific or technological research suggesting that water or dirt or damage to the phone would cause the phone to inaccurately log wired headphones in or wired headphones out. So one of my other opinions here is a lot of this is shocking. A lot of this is horrible. A lot of this points to injustice. Some of it, to me, I think they should have been able to present this. I'm not sure it's enough that's going to win on an appeal, this argument. All right. According to Apple Health data on LG's iPhone 6, the phone stopped moving at 2:32 on February 13, 2017. At trial, the state contended LG and AW died close to that time, and AW hid the phone under her body before she died. The state also provided testimony by former Delphi Police Chief Steve Mullen and Indiana State Police Lieutenant Jerry Holman. There was no evidence that Richard Allen returned to the location where the bodies were found after allegedly being spotted by Sarah Carbaugh at approximately 3:50 p.m. February 13, 2017. If Ms. Eldridge's actual expert opinion that wired headphones were plugged into the phone at 5:44 p.m. and unplugged almost 5 hours later were credited by a jury, the state's narrative is impossible. Someone other than Richard Allen was handling LG's phone multiple times long after the state contended Mr. Allen left the scene. It's possible. Mr. Eldridge's opinion that dirt or water could not have caused LG's phone to log wired headphone plug-in and unplugged headphone on February 13th exculpates Mr. Allen. My opinion is that's giving them a theory. Is that a smoking gun? Far from it. Just my opinion. Just my opinion. And then they get to the conclusion. Sleuthy said the witnesses had not communicated this new theory to the defense before he testified on the stand today. Did I miss that somewhere? I don't know what that's from. He didn't say anything about the box cutter in his depot. He spoke to the prosecutor several times between the depot and now, but at no point talk to the defense to raise this epiphany with the defense. Right. But is there somewhere that says that he actually disclosed that opinion to the prosecutors? Maybe there is. I don't know. A lot of this I don't know in this case. That's why I got to kind of discuss both sides of it. So if it was disclosed to the prosecutor, I think it's a discovery violation. If it wasn't disclosed to the prosecutor and something brand new, epiphany brought up at trial, like they said, should have been struck. Kind of simple, from my opinion. It should be a simple call from the judge. And if you remember, multiple lawyers that were there, I can't remember who. I want to say Andrea, I want to say Bob. I'm not positive. But a lot of them were saying things like the defense needed to hit the timeline. Why didn't they hit the timeline more? The timeline doesn't fit. The state wants to package it in a box. And what I'll say is they were right, in my opinion, because when we hear from that juror, and when I've heard from some other people that, maybe do some podcasts out there or whatever, as to why they think it was him, the timeline was a big point. Who else could it have been? Bridge guy was there at that time. Allen puts himself there at that time. The phone data, the white van, et cetera, et cetera. The timeline was big. And it sounds like the defense had a ton of arguments against. Now, maybe a lot of the arguments they wanted to make were struck by Judge Gohl and they weren't allowed to get into them. I really think that's going to be a big question. If we get a completely unbiased judge that looks at this and is just like, they had not one hand, but two hands tied behind their back in defending this case. To me, from the beginning, Odinism or not, right? Odinism or not. The third-party culprit defenses should have been allowed to be presented to the jury. To find no nexus or plausibility is wild to me. It's absolutely wild to me. People making confessions or putting themselves there or potentially their DNA at the scene for no reason when they're not in prison, not even really being questioned. For them to do that versus somebody who's been in prison in the worst of conditions, although the juror said it wasn't as bad as she thought it was going to be, eventually confessing months and months and months later after denying, while he was being interrogated potentially overly harshly, is kind of wild to me. Tina Barrett, Peter, if Gohl doesn't give a hearing and it goes to appeal, will all the evidence you just read have been seen as fact by the court? No, it's not going to be part of the trial transcript. I don't know what they were allowed to put on the record as far as what they would have put in as far as third-party culprit defense. But if they didn't argue this, if they weren't able to make a record with a proffer, an offer of proof to say, we would have called Logan, we would have put him on the stand, we would have, he's no longer with us. We would have called Ricky or the officer. We would have gone through Logan's confession. We would have connected the box cutter that the expert said. We would have connected the timeline. We would have done X, Y, and Z. Judge didn't allow us to. Then it would all be on the record. So I don't know what was put on the record and what was not. But if they're just arguing it here for the first time, it's not going to be record evidence on appeal. And that could create an issue. They could potentially lose out their opportunity to even make some of these arguments, which then would go to the ineffective assistance of counsel claim. Heidi HC, do you think this was a fair trial, Peter? I don't think this was a fair process to Richard Allen from the jump. I think we covered multiple instances where Judge Gohl made this unconstitutionally difficult on Richard Allen. And the stuff we didn't get to about, not allowing him to have counsel present before he was transferred and all him being under a pseudonym, like a fake name, and not telling his lawyer. So when his lawyer looked up at what jail he was in, the lawyer couldn't even find him. When the lead prosecutor and lead officer on the case knew he had a lawyer. That's what really pisses me off about people that hate lawyers and hate defense lawyers and prosecutors that are on their high horses. I can say that I was a prosecutor, that act like they're white knights. And it's like, to step on people's rights to try to prove your point makes you a scumbag. I'm not saying that happened in this case. I don't know what happened. But if you know somebody has a lawyer and you intentionally do things to keep them from their lawyer, you deserve the worst kind of penalty that exists in the American legal system. What are you afraid of? If you're so sure Ron Logan didn't do this, if you're so sure all these other guys didn't do this, tell the jury. Tell them the officers cleared him, right? Jurors trust cops generally. We cleared him. It only could have been Richard Allen because that's what it should be. Beyond a reasonable doubt should be. It only could be this guy. His confession makes too much sense. He was there. He matches the description of bridge guy. That's what it should be. That's really what it should be. And that's why I'm not a big, juror blamer in this case, because what was presented to them throughout the entirety of the trial, I could understand how they could come to a guilty verdict. When you hear these confessions, you see the discussions and some of the witness testimony, you hear that an expert was allowed to testify to the bullet stuff. I get it. I get it. And I understand why a lot of people, if really what they know about the case is what was presented, why they think he's guilty. I understand that. I know there are people saying he's absolutely innocent. I don't know that. I don't have a feeling that he was innocent. I have a feeling that his rights were stepped on. That's the vibe I get, the feeling I get, the facts I feel are true based on what we've seen go through this case. And that sucks. That's the worst. I don't want to see that. I want to be sure when people get convicted. I want to be confident when people get convicted with a just outcome, justice for the victims, justice for everybody. Peter, if an appeal wins, will there be a new trial? Am I right? Would there be a new judge or the same judge for the retrial usually? So yes, there'd be a new trial if he won his appeal. It depends. It could be the same judge, could be a different judge. Truth and transparency. Peter, isn't it so simple as to say the best part of the motion is that Nick knew that Brad was lying when Brad said he came home at 2:30? Can Nick be sanctioned? If he knew, yes, he can be sanctioned. I don't think it's simple to say that he did know. If the defense didn't remember this and didn't see X, Y, or Z, then maybe he didn't see it. It doesn't make it newly discovered evidence. If he argued something that was factually wrong and it was done in error or by mistake, that's going to be something the appellate court will have to determine. Now, the knew or should have known, should he have known? I mean, I think his best argument is the defense didn't know it was there either. Judge, this was a video none of us really watched. The witness said he got home at 2:30. So I argued what the witness said, and that was in evidence. I personally think that should be enough for a new trial. If he truly didn't know, and it was just negligence, and he didn't see that piece of evidence, and he just made a mistake, still should be a new trial. Huge fact, huge issue, new trial, and maybe he doesn't get sanctioned if he didn't know and he didn't purposely do something wrong. If he did know, he deserves to get sanctioned. Absolutely. Eliciting false testimony, it's committing fraud on the court. Welcome to Michelle and all the new members that joined today. All right. That's all we got. It was, really interesting to me, really bombshell stuff. I would be absolutely shocked if Judge Gold did anything with this. Frankly, from her perspective, she probably isn't even going to take a hearing. She's like, what do I need to do? This is not my problem anymore, basically. That's what I expect to happen. I will be surprised if the court does grant a hearing, but I think the defense knows this is all going to be stuff they're going to try with the higher courts, with the appellate courts. And I do expect to see an ineffective assistance of counsel claim eventually. Maybe not always the first thing, but eventually I expect an ineffective assistance of counsel claim. And I don't think these lawyers will be upset about it or feel slighted by it. I really don't. It's just my opinion. But hopefully you guys enjoyed it. Hopefully you learned something. Thank you so much for giving your opinions. I know there's always some wild stuff in the chat in this case, but I appreciate it. I followed a lot of it. I appreciated your guys' comments and questions. Really great questions. You had a lot of the same questions that I had as I was reading through this. Some of them I still have. You guys also provided some clarification for the people that were either there or followed the analysis of people that were there. So I appreciate that. And I see people saying Brad Weber changed his story from what he told the FBI. That happens more than you would think. And that's why we're allowed to impeach him. And we're allowed to tell the jury, don't believe this witness. They're lying. They changed their story. And guess what? If the jury still believes that witness and believes the timeline and believes they got home at 2:30, that's sometimes how we get to guilty verdicts. But that's all we got. I appreciate you guys so much. Make sure you're subscribed to the channel if you haven't already. We're this close to 450,000 subscribers. I would appreciate that a ton. And please hit the like button on the video. Till next time, we are out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the lawyer you know.